Hey everyone and welcome back to your channel Lawpedia. So आज के हम अपनी इस वीडियो में समझेंगे Fundamental Rights Article 12 which essentially deals with your definition of state. So let's get started with the video. So now जब आप अपनी fundamental rights पढ़ेंगे you will realize that most of the fundamental rights are claimed against the state and not against the private bodies. And if you read your Article 14, it reads as, the state shall not deny to any person equality before law or equal protection of the laws within the territory of India. So अब एक question आपके दिमाग में आ सकता है कि what is state? So आपका Article 12 कहता है, in this part, unless the context otherwise requires, the state includes, mind you ये एक inclusive definition है, government and parliament of India, government and legislature of each state, all local authorities and other authorities within the territory of India or under the control of the government of India. So first three terms काफी easily आपको समझ आ जाएंगे कि government and parliament of India state होगा, government and legislature of each state होगा and all local authorities such as पंचायत and municipal committees भी आपकी state होंगी. However, जो एक difficult term है हमारा समझने के लिए that will be other authorities. So since ये constitutionally defined नहीं है, Supreme Court ने इस पे काफी सारी judgments दी हैं and with reference to those judgments we have come to a specific conclusion कि how will we define other authorities, what will be the scope and ambit of the term other authorities. So जब भी हम एक अथॉरिटी की बात करेंगे या तो वो स्टैट्यूटरी होगी या नॉन स्टैट्यूटरी होगी. स्टैट्यूटरी मीन्स क्रिएटेड बाय अ स्टैट्यूट एंड नॉन स्टैट्यूटरी मीन्स created under general law like the Companies Act or the Societies Registration Act. So now let's quickly see the first few cases pertaining to your Article 12. So, जब हम अपनी other authorities के बारे में बात करेंगे, the Supreme Court has developed a concept known as instrumentality of state. सबसे पहले हम ये term समझ लेते हैं, what do we mean by instrumentality of state? Now, as the state has evolved, उसने ये realize किया कि काफी सारी activities, welfare activities होती हैं and state may not be able to perform all of them. And इसी के लिए state ने बनाई corporations. Corporations basically क्या act करती थी? Instrumentality of state means they were an instrument of state for acting within a society. So एक तो state होता था जो basic structure act जैसे parliament, legislature और एक होती है instrumentality of state. Also, court ने ये कहा है कि state is an abstract entity. It can only act through instrumentality. So I hope आपको instrumentality of state का concept clear है. Now let us move on to the case laws. So the first case law that you will need to read under this particular topic will be Sukhdev versus Bhagatram. So इस particular case में आपका क्या हुआ? Three statutory bodies that were Life Insurance Corporation, Oil and Natural Gas Commission and the Finance Corporation were held to be authorities and thus fall within the term state as per Article 12. और कोर्ट ने ये कहा कि even though in reality bodies were constituted for the commercial purposes, it is not mandatory that you will not treat it as an instrumentality of state and you will not define it under your Article 12. और कोर्ट ने ये भी कहा कि इन तीन स्टैट्यूटरी बॉडीज की इंडिपेंडेंट पर्सनालिटीज हैं, बट दैट डज नॉट मीन दैट दे आर नॉट सब्जेक्ट टू द कंट्रोल ऑफ द गवर्नमेंट और दे आर नॉट इंस्ट्रूमेंटलिटीज. सो इवन दो इंडिपेंडेंट पर्सनालिटीज हैं, इवन दो कमर्शियल पर्पसेस के लिए कॉन्स्टिट्यूट की गई हैं, स्टिल दे कैन बी कैटेगराइज्ड एज स्टेट अंडर आर्टिकल 12. सो नेक्स्ट केस इज योर Sabhajit Tewary versus Union of India. So in this particular case, Supreme Court ruled that Council of Scientific and Industrial Research was not state as per Article 12. आपकी Council of Scientific and Industrial Research is basically a body registered under the Societies Registration Act. That means ये एक non-statutory body थी. However, इस particular case में government had a good deal of control दैट मीन्स एक तरफ ये नॉन स्टैट्यूटरी है, एक तरफ गवर्नमेंट का बहुत ही एक्सटेंसिव कंट्रोल है काउंसिल ऑफ साइंटिफिक एंड इंडस्ट्रियल रिसर्च में, स्टिल उन्होंने ये हेल्ड किया कि इट विल नॉट बी डिफाइंड एज स्टेट एज पर आर्टिकल 12. सो इस केस में कोर्ट ने एक डिफरेंट इंटरप्रिटेशन ली फॉर योर अदर अथॉरिटीज स्टेटेड इन योर आर्टिकल 12. नेक्स्ट केस आता है आपका सोम प्रकाश वर्सेस यूनियन ऑफ इंडिया. इस केस में सुप्रीम कोर्ट ने अपनी इंटरप्रिटेशन चेंज कर दी. इस केस में सुप्रीम कोर्ट ने कहा कि a company will be defined under Article 12 and the key factors for consideration will be presence of state behind the operation of body and the ability to affect legal relation by virtue of the power. So कोर्ट ने ये कहा कि हम फंक्शनल टेस्ट देखेंगे, एक ऑर्गेनाइजेशन स्टैट्यूटरी है या नहीं है वो इतना मैटर नहीं करेगा, बट वी विल सी द की फैक्टर दैट इज whether there is a presence of state or not when we are seeing a company, a statutory or a non-statutory body. And court ने ये कहा कि a corporation acting as an instrumentality of state would be subject to the same limitation as in constitutional plus administrative law as the government itself. So I hope now you understood what is the difference between Sabhajit Tewary versus Union of India and Som Prakash versus Union of India. जहाँ की पहले केस में सुप्रीम कोर्ट ने ये कहा कि कंट्रोल का कोई भी फैक्टर नहीं होगा डिसाइड करने में कि whether it will fall under Article 12 or not. Som Prakash versus Union of India में Supreme Court said that a company is a state and falls under Article 12 because of the presence of state behind the operation of body. And एक functional test define किया सोम प्रकाश versus Union of India में. Now, the next important case that you must read is Ajay Hasia versus Khalid Mujib. So एक particular college था जो जम्मू एंड कश्मीर सोसाइटीज रजिस्ट्रेशन एक्ट के अंडर क्रिएट किया गया था. So they were contending that they should not come under the Article 12. Supreme Court observed that the composition of society was dominated by the representation from the central government. The money was provided by the central government. The rules required prior approval of the state, and the audited accounts were submitted to the state and central government. It concluded that we can see a deep and pervasive control of the central government, and it will be categorized as state as per the Article 12. So we will see in this particular case, Supreme Court also highlighted certain tests जो इसी के पहले इंटरनेशनल एयरपोर्ट अथॉरिटी केस में सुप्रीम कोर्ट ने डिफाइन किए थे. उन्हीं टेस्ट पे सुप्रीम कोर्ट ने अजय हासिया वर्सेस खालिद मुजीब में भी ये कंक्लूड किया कि one particular factor will not be the sole factor. We will need to see a holistic picture to understand whether it will fall under Article 12 or not. So now let us see an important case in which Supreme Court defined what are the broad guidelines or what are the broad tests we need to see when we are defining other authorities in terms of your Article 12. So in the case of R.D. Shetty versus International Airport Authority of India, Supreme Court observed certain tests or certain guidelines which may be followed when you're defining other authorities in your Article 12. इस केस में सुप्रीम कोर्ट ने ये हेल्ड किया कि इंटरनेशनल एयरपोर्ट अथॉरिटी which was an authority created by the International Airport Authority Act was an instrumentality of state. So अब क्या broad guidelines use करी सुप्रीम कोर्ट ने, that becomes important because these particular guidelines have been used throughout your various judgments as per the Supreme Court. First is the entire share capital is held by the government. So अगर कोई ऐसा केस है in which the entire share capital of the body, statutory or non-statutory or any other body is held by the government, it will become easier to infer that it is an authority or it is an instrumentality or state. Second is financial assistance. अब अगर एक सब्सटैंशियल अमाउंट ऑफ मनी गवर्नमेंट ही प्रोवाइड कर रही है उस पर्टिकुलर बॉडी को, सो आप एज्यूम कर सकते हैं कि येस इट इज एन इंस्ट्रूमेंटैलिटी ऑफ स्टेट एंड द स्टेट इज मेयरली एक्टिंग बिहाइंड द कॉर्पोरेट व्हील ऑफ दैट बॉडी. थर्ड इज द बॉडी एंजॉयज मोनोपोली स्टेटस. given by the state. अगर कोई बॉडी है जो एक मोनोपोली स्टेटस एंजॉय कर रही है, मोनोपोली स्टेटस मीन्स वो ही उस मार्केट में सोलली ऑपरेट कर रही है, वेदर प्रोवाइडिंग सर्विसेज और डिलीवरी ऑफ अ पर्टिकुलर प्रोडक्ट, एंड ये पर्टिकुलर स्टेटस उसने एक्वायर नहीं किया है, रादर उसको स्टेट गिवन है. सो इफ दैट्स द केस, वन कैन इन्फर दैट इट इज एन इंस्ट्रूमेंटालिटी और एन ऑर्गेनाइजेशन ऑफ स्टेट इटसेल्फ. नेक्स्ट इज एग्जिस्टेंस ऑफ स्टेट कंट्रोल. ये बहुत इंपॉर्टेंट फैक्टर है जब भी वी आर अंडरस्टैंडिंग वेदर इट विल कम अंडर अदर अथॉरिटीज और नॉट. Funding and control become a very important factor. So if state is exercising excessive control, that means like central government is appointing certain members, central government can remove certain members from the governing board of the body. That means कि बहुत ज़्यादा control आपकी government exercise करती है उस body पे. So that can also be deemed to be other authority as per Article 12. And lastly, the functions performed by the body are of public importance. So, अब अगर एक body ऐसे functions perform करती है which are of public importance, that means ऐसे functions सिर्फ एक public authority ही perform करेगी for the benefit of citizens or for the benefit of general public. So आप इसको भी deem कर सकते हैं कि that may be a public authority or that may be other authority under Article 12. So please do remember ये जो general point Supreme Court has stated in your R.D. Shetty versus International Airport Authority of India as tests or as some of the parameters you need to see when you're defining your other authorities as per Article 12. So now another important case that you must note is Pradeep Kumar Biswas case. So इस particular case पे Supreme Court ने क्या observe किया? Whether a body is financially, functionally and administratively dominated by or under the control of government. So इस particular case में Supreme Court ने ये कहा कि जो टेस्ट फॉर्मुलेट किए गए थे आपके इंटरनेशनल एयरपोर्ट अथॉरिटी केस में and which were again used in your Ajay Hasia case are not rigid set of principles, so that कि अगर एक बॉडी की शेयर कैपिटल मेनली गवर्नमेंट ने प्रोवाइड करी है, you will categorize it as other authority as per your Article 12. No, कोर्ट ने ये कहा कि आप क्यूमुलेटिव फैक्टर्स देखेंगे, आप देखेंगे उसकी फाइनेंशियल ऑपरेटेबिलिटी, फंक्शनैलिटी, एडमिनिस्ट्रेटिव and your other dominance and control of government. So while you're observing the test or the broad guidelines, just in case one of the guidelines or the tests are fulfilled, आप उसे other authorities नहीं करेंगे, rather you will look at a holistic picture. अगर एक कंट्रोल है जो सिर्फ रेगुलेटरी है, आप उसे स्टेट नहीं कैटेगराइज कर देंगे as per Article 12. I have included a particular case, that is the Telefilms, in this point in which the control was mere regulatory and Supreme Court ने ये कहा कि it will not be state as per Article 12. Main test I have already stated is funding and control. Next, I have included these two examples. First is your statistical institute, which was categorized as an authority as the composition of body included various members of the central government, and the central government had a dominant role to play in terms of the composition of the body. Also, the money was funded by the central government and it has to comply with the directions of the central government. So अगर एक holistic picture देखी जाए, your composition of the body was regulated by the government, money was funded by the government, and the institute had to comply with the directions of the central government. Another is your Indian Council of Agricultural Research. This was also categorized as authority under Article 12. So I hope आपको ये particular case comprehensively clear है. Also please remember, आपके प्रदीप कुमार बिस्वास केस में सुप्रीम कोर्ट ने ओवररूल किया था सभाजीत तिवारी को, as it held in this particular case that Council of Scientific and Industrial Research is an authority under Article 12. Now let's move on further. So now some of the other case laws which you can read are Rajasthan State Electricity Board versus Mohanlal 1967. So इस particular case में Supreme Court ने क्या देखा था कि whether Rajasthan Electricity Board was an authority within other authorities as stated in your Article 12. एंड सुप्रीम कोर्ट ने ये कहा कि अदर अथॉरिटीज विल इंक्लूड ऑल कॉन्स्टिट्यूशनल प्लस स्टैट्यूटरी अथॉरिटीज ऑन whom power is conferred by law. Now the second case is R.D. Shetty versus International Airport Authority. So ये particular case हम already discuss कर चुके हैं. इस केस में सुप्रीम कोर्ट ने इंटरनेशनल एयरपोर्ट अथॉरिटी ऑफ इंडिया को स्टेट कैटेगराइज किया था बेस्ड ऑन द वेरियस फैक्टर्स स्टेटेड इन द केस इटसेल्फ. Now the next case is Ajay Hasia versus Khalid Mujib. So we have already discussed this case as well. In this particular case, Supreme Court held a society as an authority in terms of your Article 12 because of the overall functioning of the society, because of the composition, because of the representation of the central government, because the money was provided by the central government, because rules prior to framing had to be approved by the central government. So जो holistic circumstances थे वो ये शो करते थे कि ये particular society is a state in terms of Article 12. Please remember R.D. शेट्टी के केस में यानी कि आपकी इंटरनेशनल एयरपोर्ट अथॉरिटी के केस में जो फैक्टर्स कोर्ट ने कंसिडर किए थे वो ही उन्होंने एज टेस्ट स्टेट कर दिए अजय हसिया वर्सेस खालिद मुजीब के केस में. सो नाउ द नेक्स्ट इज जी टेलीफिल्म्स वर्सेस यूनियन ऑफ इंडिया. सो इस पर्टिकुलर केस में वी टॉक अबाउट द बोर्ड ऑफ कंट्रोल फॉर क्रिकेट एंड सुप्रीम कोर्ट सेड it is not a state as per Article 12. सुप्रीम कोर्ट ने कुछ फैक्टर्स भी स्टेट किए कि फर्स्टली इट वाज नॉट क्रिएटेड बाय स्टैट्यूट, कोई भी पार्ट उसका शेयर कैपिटल का वाज नॉट हेल्ड बाय द गवर्नमेंट, कोई भी फाइनेंशियल असिस्टेंस नहीं दी गई है बोर्ड को बाय द गवर्नमेंट, एंड एब्सेंस ऑफ एनी कंट्रोल ओवर द बोर्ड. एंड जस्ट फॉर द फैक्ट दैट इट इज रेगुलेटिंग द क्रिकेट इन आवर कंट्री हम उसे स्टेट नहीं कहेंगे एज पर आर्टिकल 12. Now last case and a very recent case would be Rajbir Surajbhan Singh versus the Chairman Institute of Banking Personal Selection Mumbai. So इस particular case में आपका the Institute of Banking Personal Selection was conducting certain exams. So कोर्ट ने ये ऑब्जर्व किया कि जो ये इंस्टीट्यूट था इट वॉज मेयरली एन एजेंसी इन द प्रोसेस ऑफ कंडक्टिंग एग्जाम. ये कोई भी एड नहीं रिसीव कर रही थी बाय द सेंट्रल गवर्नमेंट. सेंट्रल गवर्नमेंट डिड नॉट हैव एनी एडमिनिस्ट्रेटिव कंट्रोल and merely a few members in the governing body were represented by the central government, and it was not constituted under a statute, and there was no control or regulation by the central government in this particular body. So जब एक holistic circumstances देखे it was not categorized as state under Article 12. So I hope आपको Article 12 comprehensively clear है. सबसे important term है हमारा other authorities. Please remember that. So I hope that's clear to you. I hope the cases were clear to you and the term other authorities and उसका scope आपको एकदम clear है. So now thank you so much for watching and please subscribe so that you get notified when I upload a video every Tuesday and every Saturday. And please remember I've planned the next video will be coming up on your Article 13 and then we'll move on to the other components of your constitutional law. Till then, stay home, stay safe and keep learning.